Hawaii's Kilauea volcano excuse me, is reported to have produced enough lava over the past 50 days to fill 100,000 Olympic-sized swimming pools. USA Today reported Thursday the figure amounts to 250 million cubic meters of lava, making last month's eruption one of the largest Hawaii has seen in decades. Since May 3rd, Kilauea has continuously erupted, destroying nearly 600 homes and forcing over 2,000 people to evacuate.
Hawaii volcano USGS warned blistering lava had been seen shooting out of Kilauea, reaching heights of 108 feet. Hawaii Kilauea volcano update: explosions, small earthquakes, blaze continue 7 weeks after first eruption. 7 weeks after the Kilauea volcano in Hawaii erupted, it's still spewing the lava that has destroyed homes and roads on the Big Island. Thursday afternoon on the island, there was another explosion at the summit of the volcano that caused a plume of gas and ash. The plume didn't reach 1,000 feet in the air, however, according to the United States Geological Survey. After the explosion, there was a slight decrease in seismic activity on the island, but it increased again later Thursday evening. Members of the USGS also found that the volcano has damaged the areas around its summit. A flyover earlier this week showed that a parking lot that closed in 2008 at an overlook of the volcano was completely gone. The road that formerly led to the parking lot is still visible, but the overlook parking lot has slumped into the crater of Kilauea, said the USGS. Kilauea is a crater within the summit of the larger Kilauea volcano. The USGS also checked on the Jagger Museum inside the Hawaii Volcanoes National Park and found that books had flown off the shelves. The walls were cracked and the floors were buckling. In addition to explosions and eruptions happening at the summit of the volcano, there is still very high activity coming from Fissure 8. Fountains of lava are filling the flowing channel, giving the appearance of a lava river running across the island. That lava is flowing to the Kapoho coastline, where the Kapoho Bay was filled with lava earlier in June. The lava is entering the ocean, mostly at one spot on the south edge, according to the USGS. That entry was causing a lava haze, or laze, plume to form. It's a dangerous area as well because the hot lava reacting with the cold ocean water can cause violent reactions that produce debris. As of Thursday, trade winds were pushing the laze plume southwest, according to the Hawaii County Civil Defense Agency. This laze is dangerous because the plume contains hydrochloric acid along with small volcanic particles that can cause irritation to the skin, eyes, and lungs. Less active fissures spewed some lava earlier on Thursday and were glowing with heat and lava. None, however, were erupting as violently as Fissure 8. Hawaii volcano eruption sparks gas explosion at Kilauea crater measuring 5.3 magnitude. The explosion at the Kilauea crater created a 5.3 magnitude blast wave, according to officials at the Pacific Tsunami Warning Center. The rim and walls of the volcano collapsed inwards, causing further destruction. Kilauea's hazardous gas continues to cloud the southeast of the island. Hawaiian Volcano Observatory HVO said the blast was not severe enough to cause a tsunami warning, but a large ash plume was produced which may affect the surrounding areas, they said. Fountains of red-hot lava from Fissure 8 are still pouring into the established channel of molten rig flowing down to the ocean at the Kapoho coastline. One main ocean entry on the south edge of the flow front at the coast is producing a plume of blaze, a noxious cocktail of superheated seawater steam laced with sulfur, hydrochloric acid and fine volcanic particles that can irritate the skin, eyes, and lungs, that is being blown inland. An HBO spokesman warned people to steer clear of the lava's ocean entry points. He said, the ocean entry is a hazardous area. Venturing too close to an ocean entry on land or the ocean exposes you to flying debris from sudden explosive interaction between lava and water. Also, the lava delta is unstable because it is built on unconsolidated lava fragments and sand. This loose material can easily be eroded away by surf, causing the new land to become unsupported and slide into the sea. Pellets and other lightweight volcanic glass fragments from the lava fountain at Fissure 8 continue to fall downwind of the fissure, dusting the ground near the vent. High winds are wafting lighter particles greater distances, and residents are being urged to minimize exposure to these volcanic particles, which can cause skin and eye irritation similar to volcanic ash. HBO field crews are still at the site tracking the fountains, lava flows, and spattering from Fissure 8. Observations are also collected on a daily basis from cracks in the area of Highway 130, and no changes in temperature, crack width or gas emissions have been noted for several days.
Hawaiian Volcano Observatory reports that Fissure 8 continues to erupt with a full channel flowing to the ocean at Kapoho. There is no immediate threat at this time. Persons near the eruption should be prepared and listen for civil defense updates. Trade winds are pushing fog to the southwest. Residents of Hawaii County who suffered damage or losses from the recent Kilauea volcanic eruption and earthquakes can register for disaster assistance with the Federal Emergency Management Agency, FEMA. The following is provided for your information. A Disaster Recovery Center, or DRC, jointly operated by Hawaii County, the State of Hawaii, and FEMA, is open daily from 8 a.m. to 8 p.m. and is located at the Kilauea High School gym. FEMA, the U.S. Small Business Administration, and state and county government agencies will be present at the center. If you need a ride, buses will be running between the two shelters and the DRC between 7:30 a.m. and 9 p.m. Free medical, dental, and eye care will be available today, June 22nd, and tomorrow, June 23rd, at Tropic Care 2018 at Kilauea High School between 8 a.m. and 5 p.m. Free breakfast and lunch will be available for children. Tropic Care is open to everyone, regardless of whether or not they are affected by the Kilauea eruption. We are on watch 24 hours a day for your safety. This is your Hawaii County Civil Defense Agency.
All persons having any business before this Honorable Supreme Court of the State of Hawaii, draw nigh. Give your attention and it shall be heard.
Please call the case.
OT 17777, 811, and 812, INRI 30-meter telescope at Mauna Kea.
We are here today, of course, on our second round of appeals following this court's decision in Mauna Kea Nainaiho. I'll refer to it as one. When
we were before this court in 2015. And during that proceeding, of course, much of the argument and the court's subsequent decision was focused on the due process issues. And this court, in a published decision, set out very comprehensive discussion and pronouncements of due process requirements, and including fundamentally in the justice system, justice can perform its high function in the best way only if it satisfies the appearance of justice. For in a popular government, justice must not only be done, but must manifestly be seen to be done. There was a discussion and citation on cases about cold stone neutrality of an impartial judge. There was a discussion and citation about this stringent rule may sometimes bar trial by judges who have no actual bias and who would do their very best to weigh the scales of justice equally between contending parties. And despite the decision of this court and the very comprehensive discussion, this case went back on remand to the Board of Land and Natural Resources, and the board, through a very, on remand there was never a hearing called before the board. So what happened is there were orders issued, despite our objections to ask for a meeting before the board, and the first order that was issued was the appointment of hearing officer Ricky Miyamano, and that was on or about May 31st of 2016. March 31st of 2016, excuse me. And along with the order that apparently was done through a procurement process, in which one of the board members was also a member of that process, hearing officer Amano also included a very comprehensive of cases that she had been involved with, about people she knew, and where she had gone to college, law school, all these various types of things. And on April 8th, she also submitted a subsequent disclosure. On April 15th, pursuant to the order of March 31st by the BLNR, the parties were to submit any objections. And at that time, they were just my clients, Mauna Kea Nainaiho et al., who were the appellants in Mauna Kea Nainaiho 1. And so we objected to her. After some research, we discovered that through the internet that she was a dues-paying member of the University of Hawaii at Hilo's Imilo Astronomy Center, a party in this action, the University of Hawaii at Hilo, and of course the Astronomy Center is the subject of the dispute. We objected to her proceeding as such because of the obvious pronouncement of this court. She was a dues-paying member of an actual party in this case. And our objections were overruled. Subsequently, hearing officer Amano, in a subsequent disclosure after our objections were lodged, had in essence stated that she had been unaware that the Imilo Astronomy Center was part of the University of Hawaii at Hilo. And in our motion for reconsideration, we added photos that were online with a big University of Hawaii at Hilo sign right in front of the center. We also raised that the renewal application has University of Hawaii Hilo emblem on it, etc. And despite our further objections and further information that we raised, of course, our objections were overruled again. And the appellees in this case essentially argue that, well, you know, this is just a casual, informal kind of membership. There was one citation about some out-of-jurisdiction case where many years before a judge had been a member of the Sierra Club, I believe. But this is, the crux of the whole thing is we would submit what the whole Mauna Kea 9901 was all about. It was about that cold stone impartiality, that appearance of justice. And again, you know, whether you characterize it as a more casual family kind of membership, I think really begs the question, because where do we draw the line as far as the process? If we're going to start making exceptions here for a sort of casual membership, as they want to characterize it, versus any kind of membership.
Mr. Werdeman, I'm sorry to interrupt you, but you're characterizing this as a kind of casual membership, and I wanted to ask you if you could develop a bit the facts that you're referring to. I mean, what, if any, facts would indicate that the reasonable impression of partiality, or that a reasonable person would consider likely to affect the impartiality of the judge? What facts?
Well, as far as my characterization, it's actually the appellee's characterization of the casual. I don't think there needs to be any distinction. It's membership with a party. That's before this hearing officer. And we would submit that also, you know, joining an organization, you know, also lends to them supporting a person, supporting their belief, their mission, their philosophies. You know, that's certainly a reason why people join organizations. And you know, this is that whole issue of stone cold neutrality and appearance of justice and appearance of being fair and impartial. I think was compromised by this membership. And
Kilauea Astronomy Center a separate entity? It's a separate nonprofit? Is that right?
not that I'm aware of. It's part of the University of Hawaii at Hilo. It's on the campus. It's part of the University of Hawaii at Hilo campus. And as I indicated before, there's a big University of Hawaii at Hilo Astronomy Center right in front of the building. I would submit that nobody in Hilo would confuse its association with the University of Hawaii.
Is it I'm so sorry. Is it an advocacy organization or an educational organization or both? What does the record show on that? In other words, does it have an express advocacy mission, or might one reasonably expect by joining in that you're simply taking advantage of the educational opportunities? What does the record show?
There's certainly, I think, the educational aspects to it. And, you know, there are exhibits that apparently included the TMT project as well. And to the extent that, you know, it includes such exhibits, I guess it could be characterized as advocacy, but nobody from the center actually that I am aware of has actually gone out and appeared in advocacy roles in very tribunals or agency hearings or anything like that.
In terms of administrative adjudicators, this court has, in Sussel, said that they're basically subject to the same impartiality or appearance of impropriety rules as judges. So I'm trying to think this through. Would it be your position that if, for example, a judge, let's say, had a membership in the annual membership in the Polynesian Cultural Center, that judge should recuse from a case in which the BYU Hawaii campus was seeking a permit, a building permit.
Yes, I would agree with that. And
by the same token, then, if a judge who had a membership to Bishop Museum, a judge would be required to recuse from a case, for example, if it involved the Charles Reed Bishop Foundation.
right, if Bishop Museum was a party to the action, a judge who was a member of the Bishop Museum, I would submit, shouldn't be participating in that.
How far do you think the disclosure requirements would go then? I think I should state then that I have been to the Kilauea Astronomy Center. I accompanied my children many years ago on their 4th grade big island trip, so I've been in there, and so I'd like to have that disclosed for the record. But do you think that that would constitute the grounds for recusal?
I don't think so, and you know, like I said, this is a dues-paying member at the time of the action who failed to disclose that after a very comprehensive disclosure. And I mean, I also cite evident partiality, although it applies, you know, as a court have discussed, to binding arbitrations. But you know, I think because of the deference that the courts give to administrative agencies in findings and conclusions, I mean, it's really a kind of limited appeal as well because of that deference. And unless we start off from ground one with a fair and impartial, cold stone, neutral arbitrator, and they had a procurement list. They could have gone to number 2 or number 3 just as well.
I know you've had a chance to think a bit more about these issues of partiality and conflict of interest. So let me ask you to focus on a couple of facts. Is it relevant to your analysis whether or not the party, in this case TMT, has any financial connection to Kilauea? In other words, whether there have been any contributions made as a result of the TMT project to Kilauea?
I mean, I think that certainly adds to the overall consideration, and that was something TMT also was a contributor, at least the predecessor entity, a contributor to the Kilauea Center.
Do you know the extent of the contribution?
I don't. I just went off of you know, this list that the Kilauea Astronomy Center had produced with gold status, diamond status, platinum status, that kind of thing. So,
well, it appears in the EIS that there's over a dozen references to Kilauea.
yes.
And much of that is with respect to the, I think, partly the mitigation that's anticipated that would involve payments. And do you have an idea whether the mitigation would involve payments to Kilauea?
I can't say definitively, but I certainly believe that they at least have a relationship as part of the mitigation to take school groups up to the center to educate them on the process, to work in tandem on those kind of efforts.
Do you know whether Kilauea was among the recipients who received over $100,000 in contributions from outreach activities that were made by the TMT project?
I don't know if it went through that through those contributions, but it appears that they at least made direct contributions to the center. I can't say for sure if it went through the I don't know if it was the Hawaii Community Foundation and then it was subsequently dispersed, but
would the decision of the hearing officer potentially have any effect on the ability of the TMT project to contribute to Kilauea?
I would certainly think so. I mean, if she ruled against them, that conceivably would have ended such contributions. I certainly agree that it would have a significant potential impact on that.
But the hearings officer didn't directly benefit from any of those contributions, right?
No, not financially, no. But I don't think that that's determinative of it. She's a dues-paying member, as I indicated, of their mission, of a party in the proceedings. And, you know, the easiest thing would have been, and even as I indicated in my reply brief, even University of Hawaii at Hilo and TMT International Observatory acknowledged that. And they had asked that she be removed as well, just because of the issue of appearance of justice. So, you know, it was only the BLNR that I guess at that point decided that, you know, they were going to proceed nonetheless and overrule our objections. As far as TMT International Observatory, I mean, they were so adamant about it is that they were filing things even before they were admitted as a party by the hearing officer, asking that Judge Romano be removed from the case.
We cannot set aside their rulings unless it's clearly wrong. So which findings or conclusions regarding the hearing officer made by the BLNR are you imagining were clearly correct?
I think the whole decision, she should have never presided over the case. And it was again a clear due process violation we would submit even before we got started with the evidentiary hearing. And when we went back on remand again, and it was after these clear pronouncements by this honorable court, we were expecting a cold stone, neutral, fair and impartial hearing officer after all of that, or as the court said, either the board or a new hearing officer. The board, I mean, this court made it clear in the first case that it was obviously going to be a new hearing officer because that first process was the BLNR had put the cart before the horse, and this whole subsequent contested case hearing was really a pro forma process. And if I could just touch real briefly on the Attorney General issue, the two deputies, they obviously were here before this court as adversaries in Mauna Kea 991, and as you know, they argued in their briefs, and this was raised in their motions, the substantive issues. I would submit that the same sort of standard should apply to them on remand, on fair and partiality, the appearance of justice, and they could have simply established a wall within their office and had some other deputies advise the board after.
They actually advised BLNR and DLNR as a neutral adjudicator throughout these proceedings, correct? I realize that is, I think the White case that you cite is distinguishable because in that case, the deputies had represented the superintendent of the Department of Education as an adversary party, and then turned around and represented the Board of Education in a similar proceeding, a related proceeding, as the Board of Education as a neutral. So I think the circumstances here are a little different.
Well, I mean, those are certainly the facts in the White case, but I don't think the court limited it to just that kind of situation. And I think the Mauna Kea 99 whole case, one, certainly clarified any issues about what is to be required by administrative agencies below. And I mean, how can you have a fair and impartial hearing officer if throughout the process leading up to that, you have attorney generals who did play an adversarial role, and they certainly played an adversarial role, and were part of the same attorney generals who advised the BLNR previously about putting the cart before the horse. So, you know,
But that actually gets into attorney-client privilege issues, correct? We don't know how the BLNR was actually advised by these deputies before, and we never will know. It seems to me that the rule you are advocating for suggests that, for example, anytime this court overturns and remands a decision of a judge, that judge and that judge's law clerk who advises that judge would no longer be able to hear the case. They would be involved in the case.
No, I think in a situation like this one where the Attorney General's clearly played an adversarial role against my clients, that they shouldn't be participating in a case like this on remand. We don't know to what extent, like you said, was discussed, but we have to assume that since they were there throughout all of the proceedings, throughout months of hearings, that there were some types of discussions. And I think it again is the appearance that this court has talked about, that, you know, how difficult is it to just have some other Deputy Attorney General advise the board and the hearing officer on remand to address that appearance of justice and impartiality and fairness.
May it please the court, I'm Clyde Wadsworth, appearing on behalf of the state of Hawaii, the Board of Land and Natural Resources, and the related DLNR defendants. A fair and respectful process, an opportunity to be heard at a meaningful time in a meaningful manner, both in reality and appearance. A procedure designed to ensure that the record was fully developed before a decision was made. That was this court's mandate in Mauna Kea and Idaho, and that's what the board provided to all parties in this matter. I plan first to address the due process issues raised by the petitioners, and then to show how the board fully complied with its obligations under Article 12, Section 7 and Kapaakai. First, petitioners cite no statute, rule, or canon that required Judge Amano's disqualification based on her family membership with Kilauea Astronomy Center, which is both an astronomy museum and a Hawaiian cultural museum. She simply held an $85 annual museum pass, which doesn't carry any more risk of prejudgment than having a Bishop Museum membership, being part of an alumni association, or even just visiting planetarium. And in her disclosures, Judge Amano made clear that she had no involvement in the control, management, or governance of Kilauea. In other words, she had no duty of loyalty. Her alleged relationship to UH was just too remote and tenuous to create an appearance of impropriety. And that's the standard we have here under Sussel, which asks whether the decision maker's impartiality might reasonably be questioned. And here,
why do you think if there was no reasonable impression of partiality, as soon as she was informed that the parties knew about it, she said, "Oh, I'm going to cancel my membership"? In other words, why would you need to do that if there wasn't already an impression of partiality out there?
Well, I think, Your Honor, she just wanted to assure everyone of her impartiality. The issue was raised. She didn't believe that a reasonable person would believe that it would affect her impartiality, but because the issue was raised, she decided to cancel her membership. I don't think it's a concession at all on her part, specifically when she expressly stated in her disclosure that she didn't believe a reasonable person that it would cast suspicion on her.
What about the fact that the proponents of the project asked for her removal? Is that correct? Isn't that correct? The parties on the other side of the proceeding asked for her to...
Actually, not on the ground that she was disqualified, Your Honor. UH specifically argued that she was not disqualified under the applicable standard. It did...
That there was an appearance, potentially? Or...
No, Your Honor. The argument was that for expediency's sake, because this was taking quite a bit of time, the repeated motions for disqualification, that because of the delay, that the board might look to appointing another hearing officer. There was also, I believe, a concern about raising potential appellate issue. But the UH specifically stated that it was not because of her not meeting. It was not because she was. Pardon me?
What would be the potential appellate issue?
Apparently the issue that we're here today with, Your Honor. There was just a concern that out of expediency, that the commission, that the board possibly looked to someone else, but it was not because she was disqualified.
I'm sorry.
Oh, I was just, the TMT explains it this way. They said, in the interest of fairness to all parties. That's what they said. And that means perhaps one could argue that it would be not fair if she wasn't disqualified.
Well, I think what TMT and UH were interested in was having an expedient end to the process and being able to get on with the evidence, Your Honor.
But it doesn't say in the interest of expediency. I mean, this is in the interest of fairness. I understand that time may have been a factor, but...
Well, it says what it says, Your Honor. Perhaps counsel for TMT can confirm what I've said about it.
Mr. Wadsworth, could I ask you a bit about your conclusion that there would be no reasonable impression of partiality with respect to the relationship, if any, between Imiloa and the TMT project? I think you heard me reference the fact that over a dozen times in the findings of fact and conclusions of law, Imiloa is referred to, and in the environmental impact statement, it says that activities have included contributing over $100,000 to the following. This is $100,000 contributed by the project, and it includes Imiloa, and I think, correct me if I'm wrong, the record indicates that at the time that the hearing officer was selected, she was a member of Imiloa. So is that something that would be relevant to consider with respect to whether a reasonable person might find impartiality?
I don't believe so, Your Honor. As Judge Castanetti pointed out, there's no evidence in the record that Judge Amano received any benefit from any contribution to Imiloa. She had an annual museum pass. That was it. I mean, if that's sufficient, I can address...
I don't mean to suggest that she would personally benefit, but would it be relevant if her decision would remove from Imiloa an important contributor? In other words, if she decided adversely in this case, could it affect the contributions to the group that she's a member of and that is actually, in this case, getting money from one of the parties?
On the first point, I don't think the record establishes that it was, quote-unquote, an important contributor. I think it's not in the record, but the commitment to Imiloa in the EIS was prospective in nature, and it was about linking science and culture. And equally in the decision and order, the references
prospectively. And, I'm not sure how much difference that makes, but in the reference that I'm referring to, it says prior to completion of the Chapter 343 EIS process, the project has been involved in a number of outreach activities. So that's since the time of prior to the completion, it says activities have included contributing over $100,000 to the following. So with my impression that this has already been contributed, would that affect your analysis as money's actually been contributed to?
It's a list of organizations that they've contributed to. Imiloa is one of them. Is that right?
Yes.
Okay. So, Your Honor, I don't know the specific amount that they contributed to Imiloa, and I don't believe it's on the record. It's in the record, and so ultimately, I believe it's the burden rests on the party asserting the disqualifying interest to establish that there's a disqualifying interest.
Well, this party, I guess you could say, the Mauna Kea party, Mauna Kea, Idaho, discovered this information and then brought to the attention of the Board of Land and Natural Resources the fact that there hadn't been a disclosure. So I wanted to ask you about that. In Madamba, that was an issue that was actually considered with respect to evident partiality, the idea that there was not a disclosure. Would that be relevant to your analysis in this case about whether there was a reasonable impression that an individual could have of partiality?
Justice Wilson, I don't believe so. HRS Section 658A-12 sets out the required disclosures for arbitrators, as the court knows, and the standards for disclosure are arguably higher for arbitrators than for judges, and by extension, administrative hearing officers, because judicial review of arbitration awards is much more limited. And here, in fact, Judge Amano made the disclosure as soon as it was brought to her attention. It was before any substantive proceedings in the contested case hearing. So she essentially made the disclosure before the hearing started.
Excuse me, one of your reasons that you actually mentioned when you basically took no position or something was that there was another mediation where you were concerned about that hadn't been disclosed. And so you mentioned that and thinking that there might be another challenge.
I think you're referring to something that UH pointed out in one of its briefs. If we mentioned it, as far as I understand, there was no argument by the parties that she should be disclosed on that basis, Your Honor. I don't believe that's an issue on appeal. Unless there are further questions on Judge Amano, I'd like to turn to the Deputy AGs. Under Clattenhoff, the role of the Deputy AGs in this case was to represent and advise the board. They never acted in a decision-making capacity. There's no conflict of interest here because the Deputy AGs represented the board at all times and never represented another party. They defended the board's decision and order in the first contested case, and they served as legal advisors to the board throughout the post-remand proceedings and the second contested case hearing. The Deputy AG's defense of the first decision and order could not create any danger of prejudgment because they never acted in a decision-making capacity. And ultimately, all public officers are presumed to have discharged their duties faithfully, and there's nothing in the record here that demonstrates that the Deputy AGs failed to properly carry out their role. Regarding board members Ewan and Gahn, the board properly denied petitioners' motion to disqualify them. Regarding Mr. Ewan, petitioners have offered no evidence that reasonably cast suspicion on his impartiality. They quote from an interview 20 years ago in which he said, quote, "I don't see what difference it would make to have a few more telescopes up there as long as you cite them properly," unquote, which is just another way of saying as long as they satisfy legal requirements. Mr. Ewan's qualified support of general telescope construction 2 decades ago has no bearing on the proposed construction of the specific TMT project today. Regarding Mr. Gahn, petitioners have offered no evidence to cast suspicion on his impartiality. The only thing they raised is that he voted on the first permit, but in fact this court rejected the same argument in Kilauea, ruling that the board did not prejudge the second permit for the ATST merely by voting on the first permit prior to a contested case hearing, whereas here the first permit had been voided. I'd like to
interrupt you, but while we're on the subject of the actions of the board members and any possible impropriety or appearance of impropriety, neither of those board members crafted a set of mitigation measures in the conclusions of law and findings of fact that would benefit a organization that they were a member of, correct? And so
as far as I know,
we're just suggesting that there does seem to be, in terms of the hearing officer, this added point that in the findings of fact and conclusions of law, the organization she was a member of is referred to a dozen times, and the mitigation measures include contributions to that group. So I take it your position is that that wouldn't be something that either the parties or a reasonable person would consider as an indication of partiality.
I don't believe so, Your Honor. I mean, most of what is in the decision order regards the substantial funds that are going to be provided to the Think Fund and to the workforce pipeline under the EIS. And as I said before,
I may stand corrected. Your view is that the findings of fact and conclusions of law don't provide for any support to Kilauea.
Don't provide support? I'm not sure which findings of fact you're referring to, Your Honor. I apologize. I don't believe that there's any evidence. I agree that Kilauea is certainly referenced in the findings of facts and decision in order. But I don't believe that there's any evidence that Judge Amano is her impartiality was affected by that, and ultimately...
Well, she is the author of the findings of fact.
But ultimately, the board had to independently review her decision and order, so she is in a slightly different position even than a judge. She's not the ultimate decision maker. The board
This is a point. Any sense of or appearance of impropriety, perhaps to some extent, was affected by the fact that the board later made a decision? Is that your view? That it wasn't her ultimate responsibility?
Yes, Your Honor.
May it please the court, John P. Minot, appearing for the University of Hawaii at Hilo. I'd like to address first the issue of the university's position regarding Judge Amano, and the specific point, the university has never taken the position that her participation in this process constituted an appearance of impropriety. If you apply the standards from the Code of Judicial Conduct, the appearance of impropriety standard would apply when the judge is an officer, director, general partner, managing member, or trustee of a party. There's no doubt that she was not any one of those types of roles by being simply a member in Iniloa. Now, putting her membership into context, her participation in this association as a dues-paying member essentially amounted to her and her husband's admission and 5 children's admission for approximately $85. If she were to buy an admission each time, the total cost would be approximately $82.50. So all she's doing is getting a $2.50 right to go and access the museum and use the restaurant facilities at Iniloa.
Would it be more relevant, I'm sorry to interrupt you, Mr. Minot, but would it be relevant if actually she had bought many memberships? Would that make a difference?
I don't believe so because, number one, it doesn't rise to the level of an appearance of impropriety under the Code of Judicial Conduct.
I understand your argument, I think, to be that as long as she's not a director or somebody that's operating in an administrative capacity, that there wouldn't be any reason for her to disclose.
Correct. And the citations in our brief point out that she would need to be in some kind of a position of power and control for this to have any impact, and she is not in that capacity as a member who simply shows up at the Iniloa on occasion with her family and uses the restaurant or views the facilities.
But I wanted to give you an opportunity to respond to the position that as long as the hearing officer is simply a member of an organization, the relationship between the organization and a party to the case is irrelevant.
I don't think so at all. I mean, it's obviously, as we argued both in our briefs and in our opening comments, that the appearance of justice, the appearance of fairness and impartiality is in jeopardy here. And
why wouldn't the appearance be taken care of by the fact that the hearing officer or the judge isn't in a position of authority or control with the organization that they are a member of and participate with?
Well, I'll use this as an example. If there was a dispute over the amount of lease, say that the Outrigger Canoe Club pays the Elks Club, and the arbitrator or the judge was a member of the Elks Club. Not on the board or anything like that, but a member of that, and they have to determine what the fair lease amount would be in the future.
Wouldn't that be a financial interest?
Well, I mean, if the person was just a member of the board.
Of the Elks?
Yes, and they have to make a determination. I mean, there would be no financial interest per se for that
the members
judge.
have to pay for annual membership for the Elks, I guess. I don't know how it works, but,
Probably something similar to what they do at the Amy Law. There's this renewal, and the fact that they are a party to dues-paying members to one of the parties, I mean, I would submit that that's clear
You're
appearance.
saying, so you're saying that the hearing officer was a dues-paying member of UH Hilo?
Yes,
Dues-paying member of UH Hilo?
yes.
Because of the membership in the Kilauea
Right.
Center. Is that okay?
And, you know, I think the bill in our council brought up this issue about expediency and as far as overruling the objections. You know, my clients, we came out with the objections 15 days after the hearing officer was named. And then when she came out with a subsequent disclosure about her membership after the objection was made, you know, we promptly filed a motion of reconsideration with all of these issues. But there shouldn't be a time requirement on due process, especially when it's being done before the hearing has even started, and that's what we did.
You know, I'm very concerned, not only because of the mayor's condition, but I'm concerned of the message that we're sending. We have gotten so much help from all over the country, and even the world, in donating funds, reaching out to give donations to this effort. And we only ask that the council understands this and tries to give us an opportunity to make this a better place to live. And I think that with Diana's presentation, it will give us an opportunity to look at looking at this budget. Nobody likes to raise taxes. Not one person wants to raise them. It affects all of us. We all pay taxes in this room. And I think Diana will make you, in this presentation, will show you. And we do not want to make cuts as well to provide services to the community. But we will work with whatever budget that is presented to this administration, which we have done for the past year and 6 months. We will be accountable. You will be able to ask us any questions in regards to the funds, of how we are spending the money. I really believe that every single director and deputy director in this county is doing a tremendous job for the people of this community and this county. They're fiscally responsible, and I have a confidence, utmost confidence in what they're doing in their leadership roles. When they're asked to cut, we've cut. Asked to cut again, we've cut again. And now it comes down to just basically revenue. The property taxes that was lost in these 3 communities alone puts us in a different situation. It's affecting this economy. It's affecting the tourism industry. It's affecting jobs in this community. Let us look at the whole island as you vote today. It takes some commitment to the people that are in need. And I only ask you to strongly consider 159. Thank you.
Thank you, Mr. Okabe. And Ms. Sako. Good morning, Diana Sako, Director of Finance. We do have a presentation, which I believe you have in front of you. And so, you know, you definitely have two options today. One is to pass the bill, and one is to, if it were to fail. And we just wanted to kind of give what would happen. If it does pass, we would come back in to amend the budget. We would, the bill also establishes the General Excise Tax Fund, so we would come in with that budget as well. But we would move mass transit, the operations that are currently in the general fund, and we would put them in the General Excise Tax Fund. And we would adjust general fund revenue to reflect the decline in real property tax revenue, and then we would be balanced, because that amount is $4.9 million, as you'll see on a later slide. And if the bill does fail, we'll have to adjust general fund revenues to reflect the decline in real property tax of roughly $5 million, and adjust general fund expenditures to reflect the decline in real property tax revenue. So if the bill fails, there's definitely going to be a budget impact. We're going to have to find $5 million in cuts, which is the same thing we talked about, 2 weeks ago. Nonprofit grants would be reduced to $1 million as required by county code. There'd be no council contingency funds. We would unfund vacant positions, probably mostly those that have been vacant for over a year. Possibly no car allowance for elected and appointed staff. We would suspend non-mandated programs and services, parks and recreation, festivals, programs, fee waivers. A lot of these things are not mandated by county code or charter. In planning, we would reduce funding for CDP, like clerical support. Maybe they wouldn't be able to meet as often. We would look at the funding for Banyan Drive redevelopment, boards and committees, and then R&D, energy, immigration, business development programs. A lot of those are not required or mandated by code or charter. Then the budget impact continues, reducing non-mandated programs or services, like, with possibly closing pools and gyms certain days each week, deferring repairs and maintenance again, public works, reducing LBC and unsafe floral, solid waste, recycling programs would be reduced, reducing training opportunities, deferring equipment purchases, and possibly closing rural offices. And we would come back in with a budget amendment so we could talk about it. But again, these are the things that were not mandated by charter or code. If the bill passes, there would be no additional reduction in programs and services. Mass Transit would have the funding it needs to make its improvements and to implement the master plan. Road projects can be addressed, and we're talking about the larger road projects that need to be rebuilt or improved. And we'd have an additional source of revenue. We'd finally be able to diversify our revenues. If it passes, this is a proposed budget amendment. This is similar to what we gave you when we first took up the bill, whatever the number was, 102 maybe. But we would reduce general fund real property tax revenue by $4.9 million, and we would move basically all of the mass transit expenses in the general fund to that general excise tax fund. So that's the first $4.9 million. Our estimate of $10 million for general excise tax has to do, we believe the first half year will be $12.5 million, but when the state starts charging it on January 1st, the collections would come in January, the businesses would remit them to the state in February, and it usually takes the state yet even longer to get them to us, so we wanted to be conservative on the number. In addition to mass transit's operations from general fund, we would look at implementing parts of the mass transit master plan. And again, this is back in February or March when we talked about the previous bill. Since then, the mass transit plan, master plan has gone out to public hearing. There's been discussion. So, we're in agreement with SSFM and, some of what Cheryl spoke about earlier today as well. But, we do need more buses and equipment. They do need to expand their routes and provide more services. They need to make capital improvements. Definitely they need to make technology improvements. People are looking forward to having an app, knowing where the bus is and when it will be coming, and then adding routes as well. Excuse me. And then, in addition, we believe it would give us enough funding to be able to design Ani Keohukalole Phase 3 from Hinalani to Kaiminani. And that would be the $10 million where it would be going to. And again, this would be in a separate fund, the General Excise Tax Fund, for accountability. The mayor has called me a couple times from the hospital to be sure that we make a couple points. One is he firmly believes this is not the time for government to be cutting services when people are most in need. It's the time for government to step up and provide additional services. And if people are going to need additional services in Puna and around the island, tourism is down, people are, being laid off or hours are being reduced. So we do want to be able to, provide help to those people as well. In addition, we just need the dollars to be able to respond to Puna. And, no one foresaw the $5 million reduction in real property taxes coming, but it is something we have to deal with now. So we humbly ask for your support. We really do believe that government will help needs to maintain stability in the community rather than decreasing right now during times of crisis.